It's a new year. And I'm not doing that this year. Did you hear me yesterday, Tip? I said, I'm not doing that this year. All right. So let's see how that's going to work out for Mr. White. That statement. I'm not doing that.
Doing that this year.
That's listen, you know, like
Judgment sprung, in and out, the verdict swung. Oouchie core watch, we've just begun. Oouchie core watch, we're on the scene. Truths unraveling, what does it mean?
So, may I have Ms.
I'm getting
Rahal?
ready to do Miss Agee. I'm gonna do Miss
Okay.
first.
Okay.
I can't get her out of there, Your Honor. She was taking her braids out, and I was explaining to her what appropriate court demeanor looks like. So she might have stepped away to get it together because I told her she couldn't put a rag or do rag on it, and now she's not responding.
I don't know what you're talking about.
We have two AGs
I'm
today.
talking about Miss Sharon Agee, and I'm ready on Sharon Agee.
Ready on
Oh, I have a Denise Agee in the breakout room. May I go try and get her out, Your Honor?
Sure. All right. This is case number 2244272201, the people of the state of Michigan versus Sharon Elizabeth Agee. The defendant is charged with 1 count of larceny. Today is the date set for a discharge from probation. Ms. Stevenson, your appearance, please.
For the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Sharon Agee. Ms. Agee, ma'am, please say your first name and last names.
Sharon Elizabeth Agee.
All right, today is the date set for review. Ms. Agee was placed on a 6-month probation period under a delayed sentence. And according to probation, Ms. Agee has completed all the terms and conditions of her probation and is ready for discharge. Ms. Stevenson.
We would move for dismissal, Your Honor.
All right, then the court is going to discharge you from probation with improvement, ma'am, and dismiss the matter with prejudice. Mr. Flanagan, I believe that Ms. Tucker may have already submitted a discharge.
Yes, Your Honor.
So Ms. Agee, have a seat at the direction of the officers, and we will get you a copy of the discharge and dismissal.
Thank you, Judge.
You're welcome. Happy holiday, Happy New Year to you, and good luck to you.
Same to you, Judge.
All right, thank you. All right, good morning, Mr. Forrest, are you there?
Good morning.
Good morning. All right. And are we ready? You ready?
Yes, Judge.
Yes, Your Honor.
All right, then this is case number 2445300601, the people of the state of Michigan versus Marcos Alexander Cervantes. The defendant is charged with 1 count of operating while visibly impaired, and today is the date set for sentencing. Appearances, please.
Good morning, Your Honor. Max Beisel, P77513 on behalf of the people.
Good morning, Your Honor. Matthew Forrest, P73168, appearing on behalf of Marcos Cervantes, who's present via Zoom this morning.
Mr. Cervantes, state your full name for me.
Good morning, Your Honor. Marcos Alexander Cervantes.
All right, today is the date set for sentencing. Oh, well, yeah. Okay, today is the date set for sentencing, and I have had an opportunity to review the pre-sentence report with respect to the same. Are there any additions, deletions, or corrections on behalf of the people?
No, Your Honor.
Give me 1 second. Why doesn't it? Okay. And on behalf of the defense, any additions, deletions, or corrections?
No, Your Honor.
All right. With respect to sentencing, do the people wish to be heard as to sentencing?
No, Your Honor.
All right. 1 second, Mr. Forrest. Mr. Flanagan, do you know who the jail is?
Yes, Your Honor. Robert Milam.
Do we have a report?
No, Your Honor. I've called the forensic center 3 times, no answer.
Did I order the, um, did I order the examination?
No, Your Honor.
So contact the felony court and see if they have it. Okay, all right. With respect to sentencing, Mr. Forrest, do you wish to be heard?
Yes, Judge. Mr. Cervantes is 28 years old. This case represents his first contact with the criminal justice system and his first conviction of any kind. He is employed as a Detroit police officer serving the community. He understands, and I've, throughout this process, it's been quite evident to me that this has had a big impact on him, and he's committed to making sure that nothing like this happens again. And I know that he wished to address the court regarding this. So I hope that you would take all that into account when imposing sentence, Your Honor.
All right. Mr. Cervantes, would you like to address the court?
Yes, Your Honor.
You may.
I'd just like to take the time and first, I'm really grateful I'm still here today, and really grateful that those people that were also involved in that incident are still here today. I tell you, I've taken a lot of time to reflect on this situation, and I don't want anything like this to ever happen again. This is not, I don't want this one incident to define me as a person and my character. I don't take this situation lightly, and I'm willing to do whatever it takes to get back on the right path and make sure that an incident like this never happens again. I'm truly grateful that everybody walked away okay. It's my biggest takeaway from this. And at the end of the day, I put their lives in danger, my life's in danger. And I regret that decision every day.
All right. Okay. The court is ready to impose sentence. I appreciate those words. Of course, as a law enforcement officer, you are aware of how dangerous that is and was, and but I often quote one of my favorite lawyers who I've never met, just of course know of his work, and then they made a movie about him, but Bryant, who says we're better than the worst thing we've ever done. And so we make bad choices. I don't consider some of them mistakes. They're bad choices. Now, Mr. Cervantes, I was disappointed when I read your pre-sentence report. I was disappointed that you tested positive for alcohol. I was disappointed in that. Your bond condition was that you were not supposed to be drinking. So in essence, you violated your bond conditions. I am ready to impose sentence. I'm not going to necessarily penalize you for that violation, but also understand that if it appears that your problem is serious, I won't hesitate to send you to sobriety court, which is more intensive, which is gonna start your probation over. At whatever point I would put you in sobriety court, now you have to do 14 months for sobriety court. That's their program. So I was disappointed that you tested positive for alcohol. But I'm going to follow the recommendation of probation at this time and sentence you to probation for 12 months. That will place us with a final review date of January the 2nd, 2026. A midway review date where you would be eligible to be discharged early from probation if you have completed the terms and conditions of the probation would be July. And I'm going to set that for July the let's see. I'm gonna set it for Tuesday, July the 15th. That review will be at 10 a.m. It will be on Zoom. If you have completed the terms and conditions of the probation that I'm going to set, then you will be eligible to be discharged early from probation. If you have not completed the terms and conditions of the probation at that first review, there's no penalty to that unless I penalize you for something else that, or send you to drug court, but sobriety court. But if you don't complete the terms and conditions, it's a year-long probation. So there won't be any penalty for not finishing early. You just won't get the benefit of that. The conditions of your probation, of course, are as follows. You shall not violate any criminal law of any governmental unit. That means no new cases. You cannot leave the state of Michigan without consent of the court. You must notify probation immediately of any change of your address, phone number, or employment status. And you will pay the following fines, costs, and fees. Oh, and you must report to probation on a monthly basis if I didn't say that. You will pay the mandatory cost of $210, a $400 fine. Counsel, Mr. Beisel, I noticed in the report that probation had not been able to reach anyone with respect to restitution. Are the people requesting any restitution at this time?
Not at this time, Your Honor.
All right. I'm going to set restitution at 0 and note that if the complaining, the victims reach out, that I'm only gonna give 2 months for them to contact someone, because if Mr. Cervantes is trying to get off probation early, it's not fair for me to leave something open. So I'm gonna set it at 0 and indicate that a restitution hearing must be requested by, this is January, February. Really, I'm gonna say in 30 days, really. But restitution hearing must be requested, I'm gonna say by February 7th.
Thank you, Judge.
Okay. All right. And then the court is going to impose oversight fees at a rate of $35 per month. That puts us at $420. There will be a $100 pre-sentence investigation and substance abuse evaluation fee. Mr. Cervantes, when you were testing, or when you tested, did you test at the 36th District Court?
Yes, Your Honor.
Is that where you want to continue to test, or do you want to go to an outside agency?
No, 36th District is fine.
Okay, so then I'm going to add the testing into the fines, costs, and fees. So I'm gonna order testing twice a month for the first 3 months. If there's no positive test, then it can be reduced to once a month. If you have positive tests in that time, then I'm gonna consider sending you to sobriety court. So the total for the urinalysis is, oops. $90, I think. I may have added that wrong. That doesn't seem right. Oh, because I didn't add after that. 30 plus. Okay, no, so it should be 150. And then if you get discharged early, we will back out any unused tests. Also, the same for the supervision fees. If you get discharged early, then the supervision fees will only be $210. The total fines, costs, and fees for the 12-month probationary period are Hold on. I don't like the way they do this new thing. Okay, 150, 210. Right. $1,280. If you plan to get discharged early, then your total is I think $1,025. I think I added that right. All right, then you also shall not use or possess any illegal substance. You cannot use or possess any marijuana without a valid medical marijuana card. You cannot use or possess any opiates without a valid prescription and letter of explanation from the doctor. I'm gonna say you cannot use any opiates. I don't know where he works. Like, I don't know his unit. And I said use or possess, but like if he work in drug task force or something, you know, he wouldn't get violated for that. You shall not consume alcohol in any form. You cannot drive without a valid driver's license. You must attend alcohol highway safety education level 1, the victim's impact panel, and watch the consequences video. I'm going to indicate that if you have any positive tests, I'm not going to order outpatient treatment at this time unless the people are requesting it. I was going to order, it is recommended by probation, but I was going to say if he had any more positive tests. Mr. Advisor, what's your pleasure?
I'm sorry, I missed that, Judge.
I said I wasn't going to order the outpatient treatment at this time, but I was going to say if he have another positive test, he must enroll in outpatient treatment, but it's recommended by probation. So I wanted to know what was your pleasure.
I would agree with the court. I think if he can maintain his sobriety without another positive test, he wouldn't need it. And if he
Okay.
tests positive, I have no objection to him then going to outpatient.
All right, so the court will indicate that outpatient treatment if positive. And then court is going to order the driver's improvement program, and there's a recommendation for 5 days of community service. I'm going to reduce that community service. 5 days would be equivalent to 40 hours. I'm going to just reduce it to 20 hours of community service. And if he holds off on the community service and does very well with the other part of his probation and comes to the halfway point complete, then I may waive the community service because he, by the very nature of his job, gives community service. But I want to see how he does. If beyond halfway point. Okay. All right, I believe that concludes my order. I am going to, the court will mail a copy of this order to the address that's listed on the pre-sentence report. I won't say even the street. And then the phone number also that's listed on the pre-sentence report. That's where probation will contact you. Anything further on behalf of the people?
No, Your Honor.
On behalf of the defense?
Yes, Judge, is the court available? I start a trial the 14th, and I just don't know that I'll be available to appear on the 15th.
Okay. I can move it up to, what did I say? The 15th, July. Then that's the holiday, so we're not here. Today is the 3rd, so it has to be over half. That's why. So that next week, it's a strong possibility I'll be on vacation the week of the 7th. But what I'll do is I'll go ahead. I can put it on the 10th.
Okay.
And then I won't move it even if I'm not here, because if he's getting discharged, someone can just discharge him, and if not, they could continue him to the next one. So I can change it to the 10th.
Thank you.
You're welcome. All right. Anything further?
No, Your Honor.
All right. We're all set. Have a great day. Stay safe. Happy New Year to you.
Thank you, Judge.
You're welcome. All right. Before I go to the people, let me hear from the people. There are 2 unidentified devices in the waiting room, but let me hear what the people have to say.
So Your Honor is correct that this was a case where we were required to confirm our witnesses. I did have the Victims Advocate Unit working on it, as well as I did. We have 2 witnesses that I have not been able to get in touch with. Neither has the Victims Advocate team. And so at this point, we are not able to proceed with this matter.
All right, I'm going to let these 2 unidentified devices into the courtroom then. And see if they are associated with this case. And the person on the device I labeled iPhone 13, can you unmute and state your name for the court? Say that again.
Hold on,
I'm sorry. What is
Edwin Rich, but I'm trying to unmute the video.
Sir, I didn't ask you to unmute a video. I asked you to state your name for the court.
Oh, Edwin Rich.
Antoine, what's your last name? Oh, Antoine Richard.
Yes.
Thank you, Mr. Richard. Accept to join the breakout room and wait for a lawyer to come in to speak with you.
Okay.
Can the person on the Samsung please unmute and state your name for the court?
Larry Graves.
Mr. Richard, you haven't accepted the breakout room, sir.
It's Larry Graves.
No, I'm not talking to you, Mr. Graves. Mr. Richard,
Yeah.
please accept to join the breakout room, sir.
All right. It ain't popping up on my phone.
It did pop up. You weren't looking. Okay, let's try again, Mr. Richard. We're gonna try again. Pay attention to your screen, and when it pops up, please accept to join the breakout room.
All right.
All right. Mr. Graves, I don't see you on my docket, Miss McLeod. Is this one of your witnesses for this case?
It is not one of my witnesses for this case, Judge.
Is this one of your witnesses, period?
I don't know. I don't see that name on my list for today.
Mr. Graves, please write down my courtroom phone number, sir, and call the courtroom so that oh yeah, this your witness, Miss. Okay, yeah. I'm gonna send him to the breakout room. This is on Mr. New. Okay. Let's send him the number 20. All right. Thank you, Mr. Flanagan. All right, so then with respect to Mr. Larkins, today is the date set for final pretrial conference, and the people have been unable to locate their necessary witnesses, the complaining witnesses, and they are unable to proceed. The court is going to therefore, I apologize. Did you make a motion?
Motion to dismiss, Your Honor.
All right. Court is going to grant defense counsel's motion dismissing the matter without prejudice. Counsel, you are in the courtroom, so there should be a form in the courtroom that you could fill out, and I can sign it. They're probably over. Oh, you look like you have one. All right. So I can assign it. Mr. Flanagan, you can bring it up to me and I'll sign it.
Yes, Your Honor.
All right. So Mr. Larkins, you can have a seat and wait for me to sign that order, and then you all will be all set. Okay.
Thank you, Your Honor.
You're welcome.
Thanks, Your Honor.
All right. You're welcome. Happy New Year again, and have a great day. Stay safe. Then this is case number 234491201, the People versus Mikhail Hakeem White. Defendant is charged with 1 count of gambling, disassociated person, and today is the date set for final pretrial conference. Appearances, please.
Morning, Your Honor. Hannah Eberhard on behalf of the people, seeking permission to practice under Michigan Court Rule 8.120. Here today under the supervision of Assistant Attorney General Robert Hayes, and I'm a 3L at Wayne State University in good standing.
Permission is granted.
Rakidia Hall on behalf of Mr. White. Mr. White, sir, may you unmute and state your first, middle, and last name for the record? Mikhail Hakeem White.
All right. Today is the day set for final pretrial conference, and it's at 9:10. So when is Mr. White's trial scheduled for?
January 7th.
Hold on. Yes, Mr. Flanagan?
My apologies, Your Honor. January 7th.
Indeed. Okay. Thank you. Ms. Hall, how are we proceeding?
Your Honor, we would be asking if the court could remove the jury trial date off the calendar. We would be asking the Attorney General to leave diversion open. Mr. White received the paperwork or noticed that he received the paperwork after the date that it indicated that he was supposed to turn it in, so he did not complete it. He would like to take advantage of the diversion program. He just wants to know if he has more time to submit the paperwork, which he's prepared to do immediately, or to complete all the steps required to enroll in diversion. So we're asking to see if they're still holding diversion open under those circumstances.
Ms. Eberhardt.
Your Honor, my notes indicate that he received, or the paperwork was mailed out on November 6th of 2024, but there was no response to that. I'm trying to find if there was a deadline.
There was. He missed it.
Okay.
So
yes.
So now that
so from my understanding, I think he could still get in. If he submitted that now, we'd be willing to do that. We wouldn't have an objection.
So given that, Your Honor, we will be asking for the jury trial date to be removed from the calendar, and we will ask for another final pretrial date so that he can take advantage of the diversion program in between that time, which he'll get on right away if the court allows.
Mr. Flanagan.
Yes, Your Honor.
When was the previous final pretrial conference for this case, please?
December 3rd, Your Honor.
So what happened on December 3rd? We didn't know we got the diversion paperwork that was sent out in November.
I don't have the answers to that, Your Honor. But this is a new year, and there's a Mr. White.
Don't make me laugh in the new year. Don't make me do that on this record. Don't make me laugh. Okay. All right. All right. Let me be clear about something. Okay. So it is a new year, Miss Hall. It's a new year. Woo! And it's a new year. And I'm not doing that this year. Did you hear me yesterday, Tip? I said I'm not doing that this year. All right. So let's see how that's going to work out for Mr. White. That statement. I'm not doing that. Listen, you know, like I don't know if you go to church, Mr. White, but at my church, in the Pentecostal persuasion, a lot of times on New Year's Eve, you know, the service, that's where the pastor gives his theme for the year. And he'll say, you know, this what we doing. And he give his theme for the year. This my New Year's Eve service. And this is my theme for the year. I'm not doing that this year.
I'm not doing that this year.
I'm not doing that this year. Okay, so as it relates to Mr. White, this is what's going to happen. I will grant you of that request to remove the jury trial that is on Mr. White's case for next week, Tuesday. January the 7th, we will remove the jury trial. All right, so Happy New Year.
Thank you.
And then I'm gonna set a final pretrial conference for Mr. White. Let me ask this question. This is to Ms. Eberhard, and it might be to Mr. Hayes, whoever can answer it most quickly. And Mr. Hayes, if it's you that's gonna answer it, just put your appearance on before you do. How long is that gonna take? So he currently has some paperwork. Does he need to get new paperwork, or can he fill out the paperwork that he has? I think Mr. Hayes was shaking his head, so I'm gonna interpret. He can fill out the paperwork that he has.
Yes, he can fill out the same paperwork, and it takes about 2 weeks.
Okay.
Once they receive that.
Ms. Hall, does he actually have the paperwork? He actually found where they sent him the paperwork.
That's my understanding. Mr. White,
Yes, it's right here.
you have the paper. Okay, thank you.
Okay.
Mhm.
All right. Final pretrial. Remove jury trial. And he needs to he has to mail it in.
Yes.
Okay, yes. All right. Today is the 3rd. We're coming back on the 24th. Now,
So, Mr. White, that doesn't give you any time to play. You need to send that out today.
Yes.
and so you want to hear the part where I'm gonna say I'm not doing that this year?
Yes.
Now, don't you now, Mr. White,
I like that.
my jury trials are too they're precious commodity.
Yeah.
So canceling a jury trial, and the jury trial is next week, I can't put a trial in its place, right? So that means I won't say wasting. That means I'm giving up a jury trial day.
Yeah.
Right? So don't play with me in this paperwork, because okay,
He's not doing that this year.
Because we're not doing
I'm not doing. Thank you so much, Miss Hall. I'm not doing that this year.
okay. I'm glad we all on the same page. And then, so Mr. Flanagan, I need to come up with a time. Look, y'all know I'm the queen of putting stuff at a particular time. We're gonna come up with a time that says I'm not doing that this year. That's gonna be a time that says if it's at this time, that means I'm not doing that this year, and it needs special attention. So
Yes, Your Honor.
right now we're gonna just put Mr. White at 9 o'clock. No, let's leave him at 9:10. We're gonna leave him at 9:10, so I'll know that he did at least have a trial date. But we're gonna take him off my book, and we're gonna put him at 9:10. But it might be something like 12 or 11, like that 11. I've never used 11. So we might put it at 11. That means I'm not doing that this year. Or, I mean, it's 25. What, do I already have some at 8:25?
Yes.
Okay, so see, I can't do 25. But okay, we're not doing that this year. All right. Oh, look, he disappeared. What happened to your client?
I don't know, Your Honor.
See,
But he
I'm
did
not,
receive the
I'm not
date and
doing,
the time.
I'm not doing that this year.
And thank you so much for your consideration.
The 24th at 9:10 right now, but it put it at 9:11. Oh, 9:11. Ah, that means some stuff gonna 9:11. Put it at 9:11. I'm not doing that this year. I don't know what happened to your client, but make sure he gets that date and time. He's gonna fill out that paperwork and send it to wherever he needs to send it. Okay.
Yes, Your Honor. Thank you.
All right, you're welcome. Have a great day. Stay safe.
Thank you, Your Honor. Happy New Year.
All right, Happy New Year.
Thank you, Your Honor. Happy New Year.
Happy New Year. But this is case number 244472401, the People versus Robert Kurt Milam. Defendant is charged with retail fraud. Today's date on my docket set for competency hearing. Appearances, please.
Good morning, Your Honor. Dawn McLeod on behalf of the people.
For the record, Your Honor, Janice Stevenson appearing on behalf of Robert Milam. Mr. Milam, sir, please say your first, middle, and last names.
Robert Kurt Milam.
All right. So hold on one second. I remember that Mr. Milam, well, in truth, I didn't remember. Mr. Flanagan reminded me that Mr. Milam has a case with where he's represented by Mr. Cripps, and that is the case that the request for competency was made on, and then we tried to find out if there had been a decision on the competency, and Mr. Flanagan, at my last asking, had not been able to obtain that information. So with that being the backdrop, Ms. Stevenson.
So, Your Honor, the competency, I believe, was requested by Attorney Cripps, as the court has indicated. Mr. Milam did advise us at his last hearing that he had, in fact, had an evaluation. I think that was on November 22nd. He told us that he had had an interview on November 21st. Mr. Milam has advised me that he was found competent and that the felony case for which the competency was requested has now been adjudicated. So I would ask that we be able to proceed today.
All right, and how do you wish to proceed?
Your Honor.
Oh, wait a minute. With respect to the competency, Ms. Flanagan, were you able to confirm that before I proceed?
No, Your Honor, I'm still waiting on Mr. Cripps to call the courtroom.
All right, no worries. With respect to the competency, the court is just going to indicate that for the record, this court did not order or request competency. And at this moment, I have nothing indicating to the court that Mr. Milam is not competent, including the fact that Ms. Stevenson, you appear to have been able to communicate with your client as it relates to this case. So I will allow you to proceed. So how do you wish to proceed?
Your Honor, would the court grant me a Cobb's evaluation?
I may, yeah, I will. Go ahead.
I would advise the court that Mr. Milam does stand charged with one count of retail fraud in the second degree. The second degree was brought about as a result of priors, not necessarily the value of the property. In reviewing the investigator's report, the items at this point still allegedly stolen were clothing items that were all recovered by the complaining witness prior to at the time of Mr. Milam's arrest. Mr. Milam has been incarcerated at the Wayne County Jail at least since August 29th, Your Honor. He has advised me that with regard to the other case he now stands convicted, of which he now stands convicted.
Ms. Stevenson, you're muffling.
Oh, I'm sorry. Okay, so the other case that he just got convicted of is felonious assault. He's been sentenced to 2 years probation. This is the last matter holding Mr. Milam in jail at this point.
Okay. You said he's been in custody since when?
At least August 29th of 2024.
And the second degree makes this what? What's the penalty?
1 year, Your Honor.
Thank you. And you're asking me if I'll give him credit for time served?
Yes, Your Honor.
Yes.
Thank you. Your Honor, Mr. Milam and I have had the opportunity to discuss this matter. He's had the opportunity to review with me an advice of rights form. It is my understanding that Mr. Milam now wishes to waive his rights incident to trial, offer the court a plea of guilty to one count of retail fraud in the second degree.
All right, Mr. Milam, your lawyer indicates you want to enter a guilty plea, sir. Is that what you want to do?
Yes, ma'am.
Mr. Milam, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes, ma'am.
When you did that, did you understand your constitutional rights?
Yes, ma'am.
Do you understand that this is a misdemeanor and therefore you have a right to a trial? However, if I accept this plea from you today, you will be giving up your right to a trial.
Yes, ma'am.
Has anyone threatened you in any way or promised you anything that was not placed on the record to get you to enter into this voluntary plea?
No, ma'am.
Mr. Milam, are you currently, well, I know the answer to this now that I think about it, but are you currently on probation or parole?
Oh, yes, ma'am.
Now, do you understand if I accept this guilty plea, it could be a violation of your probation or parole? It probably won't be because this case happened before you got on probation, because you just got on probation.
Yes,
So,
ma'am.
all right. With that understanding, do you still want to enter into this voluntary plea?
Yes, ma'am.
All right. Raise your right hand for me. Do you swear or affirm that the testimony you're about to give, sir, will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, ma'am.
All right. Ms. Stevenson.
Thank you, Your Honor. Mr. Milam, on March 5th of 2024, were you present at 1301 West 8 Mile Road in the city of Detroit, commonly known as Myers Stores?
Yes, ma'am.
And when you were there, was the store open to the public?
Yes, ma'am.
And did you try to leave the store with some clothing items that Meyer was offering for sale without first paying for those items?
Yes, ma'am.
Thank you. And Your Honor, for purposes of the plea, we would stipulate that the value of the property stolen, according to the complaint, was $200 or less. But we would also stipulate to a prior retail fraud conviction, Your Honor, from 2019, and with that, defense is satisfied.
Are the people satisfied? Well, I'm sorry, do the people stipulate?
The people do stipulate to the amount of the goods, as well as the fact that they were retained, and the people are satisfied.
All right, the court will receive the stipulation, and with the stipulation, the court is satisfied with the factual basis, and I will accept a guilty plea to 1 count of retail fraud, 2nd degree. Ms. Hall, I sent Mr. White to the breakout room so you could tell him he logged back in. I don't know if she's there. Oh, yeah. All right. With respect to sentencing, is there any objection from the people to immediate sentencing, with understanding that Meyer, if they chose to, could appear and give a victim impact statement? They have not ever done so in the past. Ms. McLeod?
No objection to immediate sentencing, Your Honor.
All right. And Ms. Stevenson, you are requesting immediate sentencing?
Yes, please, Your Honor.
Would the people like to be heard as to sentencing?
No, Your Honor, we would leave the sentencing to the discretion of the court.
All right. Would defense like to be heard with respect to sentencing?
Your Honor, Mr. Milam, even though he's been in jail since the summer, still has a place to live, still has family support. I have good contact information for him. That was really the first thing I wanted to know is, do you have some place to go after you get out of jail? He's going back home, still has his home. It's the same address that he gave up. Mr. Milam does have some issues that he's been struggling with, Your Honor, but part of his conditions of probation on the circuit court case are going to require that he submit to random urinalysis. I think he said every week. So that's going to take care of, whatever has been bringing these cases about. Mr. Milam is, the world looked a little bit different when he went to jail than it looks right now. Missed all of the holidays, and he's ready to get back home, Your Honor. So I would ask the court to give him credit for the time that he has served, close this matter out, let him deal with the probation and the other case, and just try to make sure he doesn't come back through here on anything like this in the future.
Mr. Milam, do you want to say anything to me before I sentence you?
No, ma'am.
Court is going to impose the following sentence. Well, Mr. Milam, I'm going to say this. So you've been in jail since August. That I'm hopeful that also means you have sufficiently detoxed from whatever you were dealing with, and now getting out, you need to go get you some help. I don't know
Yes, ma'am.
if it's alcohol or drugs, but you need to get you some help so you don't find yourself back in this situation, okay?
Yes, ma'am.
Court is going to impose 93 days in the Wayne County Jail, credit for 93 days served, and close the matter out.
Thank you.
You're welcome. Anything further?
Nothing further on behalf of the people, Your Honor. Thank you.
Nothing on behalf of Mr. Milam. Thank you, Your Honor.
Mr. Milam, you're all set. You have a great day. Stay safe. They should be letting you out since you're on probation on the other case. And Happy New Year to you.
Yeah, thank you.
You're welcome. All right, I'm ready on Williams. This is case number 244438301. The People versus Anedra Odessa Williams. Defendant is charged with assault or assault and battery. Today is the date set for final pretrial conference. Appearances, please.
Good morning, Your Honor. Dawn McLeod on behalf of the people.
Rakidia Hall on behalf of Anedra Williams. Ms. Williams, may you unmute and state your first, middle, and last name for the record?
Anedra Odessa Williams.
All right, Ms. Hall, how are you proceeding?
Your Honor, this was a case where there was a pretrial settlement for Ms. Williams to go to grief counseling, and the case will be dismissed. Ms. Williams has been attending grief counseling. The complainant in this case is her mother. They actually have been speaking, mending their relationship. Ms. Williams intends to continue going to grief counseling, and she believes that it's been very beneficial for her. So we do first want to thank the court for keeping this case, because this was a case that could have been transferred, and allowing this pre-trial settlement to occur, because I do believe that this has had a beneficial effect on the family. Ms. Williams indicated that it was okay for me to share her news that she is currently expecting, and her mother will now be a grandmother, and they are working on mending that relationship, and she's going to be reaching out to her mother more regularly. So we do want to thank the court, and we also want to request a dismissal because the terms of the pretrial settlement has been met.
Well, that's Happy New Year. Happy New Year, Miss Williams. Was this on my trial docket? Is that
No, do you remember this case, Judge? We begged and begged and begged
Yeah,
you to
I
keep
remember
it.
this case because it's her brother, two brothers died or something like that. And yes, I remember, but I thought in all that begging, oh no, because it's at 9 o'clock. Okay, I thought in all that begging, I still made y'all get on my trial docket. Okay. Well, this is great news. This is great news to hear. So, Miss McLeod, are the people satisfied with Miss Williams?
Your Honor, the people are satisfied. Congratulations, Miss Williams.
All right, and so, well, I'm gonna technically deny the defense counsel's motion for dismissal, but the people can dismiss the case with prejudice on the people's motion.
We'll do that, Your Honor.
All right, so the court will sign the dismissal with prejudice. Miss Williams, was the grief counselor helpful? Has it been helpful?
Yes, it has.
I told you.
I noticed, like, I hold on to a lot of things. I'm very emotional, sentimental.
Yes.
So I'm pretty much, with the sessions, I'm learning how to, be aware of it, but not let it really affect my relationships with people.
Right. I told you. I mean, sometimes we think we're processing okay. Like we're like, no,
Right.
I'm fine. No, you're not fine, because you need a place even to be able to let out your emotions, to just be able to tell somebody, this is what I'm feeling, and I'm angry about this, so that they can help you work through it. You're angry about that, but why are you showing that anger towards a particular person? So, I'm happy for you. And have you ever seen some little kids, they just seem mean and angry? I'm talking about little kids, like little bitty kids. And I be thinking they mama was angry the whole pregnancy.
Yeah.
So I'm glad you're working through this so that you don't give birth to some little angry baby.
Oh,
Miss Williams. And I'm sure your mother is happy because, she'll get to, be involved, as involved as you, allow, but that's just wonderful. So we are going to dismiss the case with prejudice and you're going to be all set. So congratulations. Good luck to you. Happy New Year and just keep it going. All right.
thank you and Happy New Year to everyone.
All right. You're welcome.
Your Honor, I did want to add for the record that the counselor that she's seeing is one recommended by Mr. Rice, who you suggested that we contact.
Right.
The grief counseling recommendation.
Listen, Mr. Rice is the junk. I don't know how I can help him. But I'm this year I'm gonna try to find a way how I can help him in staying within my judicial boundaries. I don't want to. I've never met Mr. Rice, and so that's a good thing because I sent a lot of people to Mr. Rice, and then he's a great resource. And I don't want his program to end. I don't know what I would do if his program had to end. I don't know how my docket would look if his program had to end. So we're going to try to help. I'm going to figure out a way to make sure that can continue, but that's great. I don't know what the, situation is in terms of payment or insurance or whatever, but I'm hopeful that you can keep it going, with that person. So that's awesome. That's great to hear. And, that's just gives me one more thing to, credit Mr. Rice with. His program is phenomenal. EVAY, EVAY, EVAY. And then his program is phenomenal. So great. All right. So Miss Williams, you have a great day. Stay safe. When is the baby due?
It is due approximately August 15th.
Okay.
So
all right.
I might bake more than expected.
Mm-hmm. Yeah. Well, look, that's gonna make for a hot summer, but you're gonna be all right. All right. You have a great day. Stay safe. Okay.
Yep, you as well.
All right.
Yep.
And we'll mail you a copy of the order of dismissal for your records.
Okay, thank you.
All right. You're welcome. Bye-bye.
Bye-bye.
All right, I'm ready on Terrell. This is case number 216156901. The People versus Michael Darnell Terrell. Defendant is charged with failing to stop at a property damage accident. Today is the date set for final pretrial conference. Appearances, please.
Good morning, Your Honor. Dawn McLeod on behalf of the people.
Rakedia Hall on behalf of Michael Terrell Sr. Sir, may you unmute and state your first, middle, and last name for the record?
Michael Darnell Terrell. Did you get it?
Yes.
Today is the date set for a final pretrial conference. Mr. Terrell is scheduled for a bench trial Monday. How are we proceeding?
Your Honor, it's my understanding that the people are not able to proceed due to not being able to confirm a necessary witness.
Ms. McLeod.
You're muted, Ms. McLeod.
Thank you. That is correct, Your Honor. We had a complaining witness, Mr. Kreigbaum, who the court required the people to make sure that he could proceed as it was a property damage accident, and we were unable to secure his participation in these proceedings. So therefore, the people are not prepared to proceed.
All right, Ms. Hall.
Your Honor, we are requesting a dismissal in this matter.
Court is going to grant defense counsel's motion. The people cannot proceed. Mr. Terrell, the matter is dismissed without prejudice. We will mail you a copy of the order of dismissal for your record. Sir, you are all set. Have a great day. Stay safe. Happy New Year.
Happy New Year to you all too. Thank you.
You're welcome.
Watch, we're on the scene. Truths unravel, and what does it mean? In the halls where stories clash, Oouchie court watch quick as a flash.